As it pleases the court, Your Lordship, I still appear for the state assisted by Advocate Marondeze.
May I please, Your Lord, I appear for applicants 1, 2, and 3.
May I please, my Lord, I appear for applicant number 4 as before.
Rest of court cases, my Lord, I appear on applicant 5 and 6 as before.
Yes, Mr. Soni.
Lord, Your Lordship will recall that at the tail end of the proceedings on Thursday, I attempted to revive a question I had raised with the witness while he was under cross-examination. And the issue was this, my Lord, whether I had correctly put a proposition to the witness as to what the outcome was in the magistrate's court in the matter of Jason Iyambo.
Yes.
My Lord, then Your Lordship indicated that I should produce the record to establish the proposition, my Lord. Lord, I've given careful consideration to the issues as they developed, and I would like to place on record the following, my Lord. Lord, the issue...
Just hold on. Mr. Mengas, I see you struggling to... You may take your chair and bring it nearer to... It's heavy. Okay. All right.
Lord, I do not want to sound as if I'm in disagreement with Your Lordship's ruling. Mm-hmm. But, Lord, as a practitioner of many years, my Lord, I reflected on the approach that has been adopted. And this is the background to the issue, my Lord. The witness had made an allegation about the outcome of the criminal trial in Iyambo. And his allegation was he didn't know what the outcome was in relation to the two charges. I then put to the witness, and I'm not going to repeat it because I don't want it to be on record anymore. I then put to the witness what my instructions were as to the outcome. My learned friend, as he's entitled to do, objected on the basis that the proposition I had put was incorrect. I looked at the record, my Lord. The proposition I had put was correct. Now, Your Lordship is quite correct. If there is a proposition that is put to a witness to which there is an objection that is raised, then the proper way ordinarily to do so would be to produce proof of the correctness of the proposition. But, my Lord, this is a different type of proposition. The proposition I have put to the witness is what the magistrate had said was the outcome of the charge in relation to a count of corrupt practices. My Lord, I feel very awkward being asked to prove that.
No, did I ask you to prove that, Mr. Son?
No.
Oh,
no.
okay.
No.
Okay.
But I'm just saying, my Lord, and this is what I want to say, that if I was reading from some ordinary statement, it would be entirely different. But I'm reading from a public record, my Lord, and all court records are public records. If I am now asked as a practitioner to prove that, there is a suggestion that, in a sense, the administration of justice is dependent on everything that is put in dispute, whether properly so or not, must be proven. I find myself in a very awkward position of saying I will not subject myself to that, my lord. So, and it's not against your lordship's ruling.
Then it appears I have a total misunderstanding. Because the way I understood you is that you raised and you said you have now received the record.
Yes.
And you wanted to show it to the witness. That's how I understood you.
Yes.
That's why I said, all right, let me, and you wanted to make copies of some pages.
Yes.
I then ruled that just make a copy of the whole issue. I'll then stand it down to the day so that you get time to make copies and to provide it.
Yes.
So as I made no ruling at all. And also I gave no direction. It's just, if you are not prepared to go that way, you are within your fullest rights to. Yeah.
And that's all I want to do, my lord. As I say, if it were, and my lord, I say this, if it was so obvious, I would have raised it on Thursday already.
Okay.
It's only after court adjourned and I reflected on what had happened. I felt very, very uncomfortable, my lord. And that is on the basis that if I read to your lordship that in this case, Justice X said X, Y, and Z, and an objection is raised about that, it brings the administration of justice into disrepute. And I say it on account of the following, my lord. It is expected that counsel would not mislead the court.
Exactly.
I have put a proposition, I've looked at the record, and what I had put to the witness is reflected in the record. If my learned friend persists in his objection, my lord, I can understand that. He's entitled to do that.
And then he can bring something to counter it.
Precisely, man. And then your lordship will see what it is. Yeah. But my lord, I don't want to bring your lordship into the dispute between counsel in this matter. So the stance I want to adopt, and I have to say, my lord, it disturbed me so much that I caused a letter on Friday to be written to my learned friends, indicating that I would be putting this position to your lordship this morning. And my position is as follows. My learned friends know what proposition I have put. If they persist with their objection, I have indicated that I feel very uncomfortable about requiring it to be proved, and in that case, the objection must be upheld, and I accept that ruling. Then I do not persist with that. But that is my position, my lord. So my position, my lord, is that unless I am directed by your lordship to produce the record, it is not my intention to do so. But, my lord, that doesn't mean that my learned friends are not entitled to produce the record. They can produce the record, they can raise it in re-examination, subject, of course, to the rules applying to re-examination. But, my lord, I want to place on record, my lord, this is not directed at your lordship.
No.
It's directed at practice. And if we do not uphold the highest traditions of the profession, Lord, slowly the institutions that sustain our democracy in Namibia are going to be eroded, and we are going to land up in a very awkward space, not only some years down the line, but quite soon. So that, my lord, is my position. As I've said, this was communicated fully to my learned friends, and they're entitled to present their point of view to your lordship. And my lord, again, I emphasize, I have the highest respect for your lordship, as I have for all judges, but especially given the manner in which your lordship has conducted these proceedings. It is not intended at anything your lordship has done or said. No.
Thank you.
Your Lordship, no one intends to mislead the court in these proceedings. That's why the state had requested for the record to be produced so that we are all certain as to what was in nature of fact said in those proceedings. And in fact, the record was, okay, it's not yet before court, but all the parties are having the record. Insofar as re-examination is concerned in this particular case, Your Lordship.
Sorry?
Insofar as the re-examination is concerned,
Yeah.
the state...
You just have to speak a little bit louder because of the noise.
Construction.
Yeah.
Yes, Your Lordship. The state still nevertheless intends to rely on the record of proceedings in the Jason Yambo matter. And it's for the simple reason that when cross-examination took place, what was put to this witness was in instance that the accused person in that particular case was discharged in terms of Section 174 in respect of one of the charges. And the impression which was sought to be created was that there was no evidence in terms of that particular count. That's why the person was discharged. If the court takes in consideration...
We all know the law, Mr. No, I can't recall Mr. Soni saying there's no evidence. All that he said is the party was discharged in terms of 174.
Yes.
Now we know that when we are all legal practitioners, if a magistrate apply 174, all that what that means is the evidence that was placed before the presiding or the judicial officer is not sufficient to sustain either a conviction or to put the defendant on the stand to raise their defense. That we all know.
Yes.
So you can't. I can't draw inferences from a legal position that is clear.
Now, in actual fact, I recorded in my notes. It was put to the witness that aspect of there not being evidence. But be that as it may, I respectfully submit, Your Lordship, that that would not be the only inference for this court to draw from those proceedings. Yes, we know the law. The law says as to when a person is discharged in terms of Section 174, but the court needs to have a clear picture as to why that person was discharged. And that will be clearly reflected in the record itself as to why the person was discharged. Was there even any evidence which was laid before that particular court for the court?
Mr. Lutubeti, when you re-examine, it's for you to clear up issues. It's for you to clear up issues that are not clear and to submit. If there are documents to be submitted, you submit them.
Yes, Your Lordship.
Whatever you are going to argue, I can't force one counsel to say. It's just that I said to, I don't know whether it's Mr. Engelbrecht or who that. I cannot tell a legal practitioner how to cross-examine. So can I tell and force a legal practitioner to submit documents? Mr. Soni has pointed his position. There's no argument about that's a position he has adopted. So what you can do now is re-examine me and we go forward.
As it please the court, Your Lordship. Thank you, Your Lordship. All right, Mr. Pinyangela?
Yeah, he still wants to.
Re-examination has not yet started.
Yeah.
I am, and it's a day for my praying for various forms of relief, as it were, from Your Lordship. I would like to apply to reopen my cross-examination on a very narrow issue. Mm-hmm. And again, my Lord, in the best traditions of the bar, I've raised it with my learned friends. I told them I intend doing this, and I told them what the issue is. Re-examination has not yet started. I beg leave to reopen my cross-examination, and I undertake, my Lord, it's a very, very narrow issue, and I can place on record, my Lord, that I became aware of this issue only last night when I arrived back in Namibia from South Africa, my Lord. So that is the application I make.
Yes, Mr. Lutubeti?
As it please the court, Your Lordship, we know that the witness has been under cross-examination for nearly 2 weeks now. We've been alerted as to what this particular issue they want to cross-examine the witness on. And, Your Lordship, we cannot allow for counsel to be reopening their cases as they wish, taking into consideration the time period cross-examination has already taken place in the time period they had to cross-examine this particular witness. Insofar as the issue that is concerned, Your Lordship, that should have been raised at the time of cross-examination of the witness. I know now it is being said that that issue, they only became aware of it recently. But the issue communicated to us, this is an issue, really, we should have been known from the time of the arrest of the accused persons. If they want to place what that issues before court in order for the court to be alerted as to what they want to cross-examine on, that can be done. But I respectfully submit, Your Lordship, that the issue is, in this sense, not a new issue at all. It's something that was in the knowledge of the accused persons, the applicants' knowledge at all material times. And they once have been instructing counsel. They knew that issue themselves, really. So they should have instructed their counsel to cross-examine on that issue on which he wants to cross-examine this witness at this stage. He can inform the court what that issue is, if he wants to, but we object for the cross-examination to take place, Your Lordship. We leave it in the court's hands.
Yes, and even in civil matters, I approach trial with not too many technical issues. Now, I've said this before in this bail application, that this is about the liberty of the subjects. It's not a game where I check who have scored how many points, who hasn't scored. And I'll try to do and to be fair to every party as much as it can be, taking into consideration that we have not yet started with re-examination. I think it's just fair that I grant. If you see, I can't stop it before I've heard what it is. If I am of the view that it's a matter that ought to have been raised long ago, I'll just say to the witness, don't answer the question.
As if there's a court.
Yeah, but I can't stop, and you see, that will be tantamount to shutting out without having given the other person a fair opportunity to be heard.
As if there's a court.
Yes. All right.
Mr. Kanyangela, good morning to you. The applicants, that's applicants 1, 2, and 3, were arrested on the 27th of November 2019. That's correct, isn't it?
Yes, correct.
Were all three of them arrested on one day?
All of them on the same day.
The three were?
Yes.
Oh, okay.
You recall that one of the questions I raised with you when dealing with the application for the search and seizure, in respect of which you had made an affidavit on the 22nd of November 2013, I said to you something must have happened between the 22nd and the 23rd, which was a Saturday, for you to hastily make an ill-conceived affidavit in support of the arrest warrant for 6 of the persons who are now accused. You remember that?
Yes.
Now, that we've been through, the arrest warrant was set aside. That's correct?
Yes.
And Mr. Esso, who had been in custody, and I think so would Mr. Gustavo, were then released on the same day.
Which same day?
On the day the warrant was set aside, namely on the 24th.
That's correct.
24th of which month?
of November, my lord. So it was the day after the warrant was granted.
They were arrested earlier than 27.
Yes, and then your lordship will recall that the evidence was that Mr. Issa was arrested, then he brought the urgent application for his release, and that was granted by consent on the afternoon of the 24th, my lord. Now, notwithstanding that effectively you could not rely on the Criminal Procedure Act, you made an affidavit which is dated the 26th of November, is that correct?
That's correct.
And then the accused were arrested on the 27th on the strength of that warrant that was issued.
That's correct.
Is it also correct that the elections, the national elections, were held on the 27th of November?
That's correct.
Now, you remember, and this is my final question, you remember I said to you that what has intrigued me throughout is I could not understand what it was that required the arrest of the accused on such an expedited basis. You recall that?
Yes.
And I raised with you, did you discuss this with other people? You remember that?
That's correct.
And you said that the person you had discussed it with was Advocate van der Merwe.
That's correct.
Of course, you didn't mention your wife, but when that issue came up, you conceded that it was also your wife.
Yes, it's my wife.
Now I'm going to put to you, Mr. Kanyangela, whether with or without your knowledge, the fact that the arrest had to be carried out before or on the day of the elections was a major factor in respect of the arrest of the accused.
I don't have any comment on that one.
Lord, those are that's the extent of my reason. I just wanted to place that on record. And the rest, my Lord, obviously will be a matter of argument.
Yes, Mr. Nikubeti.
As it please the court, your lordship. Mr. Kanyangela, in cross-examination, it was put to you by Advocate Patela. He had indicated that the bail amount that he can pay, he indicated where his mother resides and where he himself resides. And it was put to you that the applicant will not abscond. You remember that?
Yes, I remember.
And your response was that it is his version.
That's correct.
I just want to find out from you, do you agree or disagree with this version?
Now, well, my lord, I'm not disputing where the applicant's mother is residing, but I will not agree. But the applicant said that he will not abscond. Take into consideration that now he knows the charges that he's facing, that are serious charges. I can still say that if the applicant is released on bail, he might have absconded. And the issue of the money, he tendered to put up. I am against any release of any applicant in this matter to be released on bail. Therefore, I could also not agree to any amount promised or to be tendered.
All right. And insofar as this case is concerned, in relation to the last question that was put to you, that the elections were a factor insofar as the arrest is concerned, were you influenced by the elections to effect an arrest?
I was not influenced by the election to arrest anybody.
All right. It was also put to you by Advocate Patel in cross-examination that his client was working on instructions insofar as the governmental objectives are concerned. What is your comment on that?
My comment on that is that the applicant in this matter is part of the syndicate that have benefited much on government objective quotas. He was put in that position, in that key position, to advance their scheme. And I may say that the directives that he was given or he was receiving that end up benefiting himself and the co-accused, that could be unlawful instruction or unlawful directives. That is my comment on that.
Okay. It had also been put to you insofar as this particular case is concerned, from your investigations, did the applicant Mike Mipunya benefit from this governmental objective quotas?
The applicant, Mr. Mike Mipunya, did benefit. He benefited from the amount of 10.3 million that Saga Seafood paid to Fine Seafood Investment Trust. He also entered into several agreements with Novanam and its subsidiaries, as well as with Loki and government objectives, quotas. And when payments was done by the entities I mentioned, some of the payments went to the entities like Njako Investment, Wanakadu, Wanyemba Investment Trust, where the applicant is having interest, which means he have benefited from such government objective quotas.
Okay. During cross-examination, just give me a minute, let me get the page. You recall that you were asked with regard to the searches that were found on Mr. Shangala's phone, whether you had approached him to inquire about those searches. You recall that?
Yes, I can recall.
And you recall it was put to you that there were certain proceedings that were being dealt with in Dubai, and he was checking on various aspects of the law in Dubai and what information he can get. You recall that?
Yes, I can recall.
And you said that you can't dispute it.
Yes, that is what I have answered.
Okay. What were the searches that were being conducted by Mr. Shangala?
The searches that was conducted, it was on the extradition from Dubai or from the United Arab Emirates.
And what do you make out of these searches as an investigating officer?
What I make out in this investigation, as I have testified already before, that there are payments that were made into Dubai on the account of Tundavala. These are the payments that are to the benefit of the syndicate. And as these applicants are interested in such money that is still in Dubai, what I can say is that he was making a search with regard to the extradition for him to see or to find out whether there's a possibility for him to be extradited from Dubai if he abscond. That is what I made out from that Google.
All right. Earlier on in re-examination, you had indicated that you were not influenced by the elections when arresting the accused persons.
Yes, correct.
I just want to find out from you, why did you arrest the accused persons in this case?
We just arrest the accused person in this case following the evidence that we have collected. We saw that we are now having enough to arrest them and bring them before court. That triggered us to arrest them.
No, okay. You also recall in cross-examination you were asked with regard to the lawfulness of your investigations, questions on the lawfulness of your investigations.
That's correct.
Okay. And there was an indication that you were investigating this matter with the police. You recall that?
That's correct.
All right. In cross-examination, there was reference to a police officer, Mr. Seron, that he took down a statement of one of the witnesses, Mr. Stephenson. You recall that?
Yes, I can recall.
And you indicated that that police officer had signed, commissioned that statement.
Yes, I did say so.
You were requested to produce that statement for the court. You recall that?
Yes, I can recall.
Okay. Do you have that statement?
Yes, I do have copies of the statement.
Can you please provide us with those statements? What do you have before you, sir?
Is the affidavit of Johannes Stephenson?
Okay. And to the court.
Yeah.
I thought the court totally provided
No,
one
she
copy.
gave you all the copies.
Oh, my apologies. I thought she gave one to the court as well. I'll give my copy to the court, Your Lordship. I'll just examine him.
Yes.
You indicated that is whose statement?
It's a statement of Johannes Stephenson.
All right. And when was it signed?
The statement was signed on the 5th of June, 2019.
Okay. And who's the signatory?
The statement was signed by Johannes Stephenson, commissioned by Jackie Saron.
Okay. Where was it commissioned?
It was commissioned at the Embassy of the Republic of Namibia, Berlin, which is Germany.
All right. Your Lordship, there's a request for the statement to be submitted as an exhibit.
The whole statement.
Yes, Your Lordship. We just referred to what is relevant for purposes of re-examination, issues that were raised in cross-examination, Your Lordship.
Or the
The parties involved, because there was that issue that was raised.
wait, not the whole content of the statement.
No, Your Lordship.
That will then be exhibit FF. Yes. Yes.
Your Lordship, the last part of re-examination will pertain to the cross-examination on the record of proceedings in the Iyambo case. I have a copy of the proceedings with me for the court. Your Lordship, these proceedings, these are judicial proceedings which are before court. And in terms of Section 235, subsection 1 of the Criminal Procedure Act, these proceedings are admissible before this court upon its mere production, even if a witness does not testify on these proceedings. On the last page, there is a certificate by the transcribers to the effect that it is a true and correct transcript of the records of the proceedings which were mechanically recorded in the matter of State versus Jason Iyambo. And the clerk of the court has also stamped his proceedings, Your Lordship. I respectfully submit that in terms of Section 235, these judicial proceedings are admissible as an exhibit. And on that basis, the state requests for these proceedings to be submitted as an exhibit, Your Lordship. Also, that this is a document which is not
You said the clerk of the court.
Excuse me, Your Lordship?
You made mention reference to the clerk of the court.
Yes, from the first page, there's a stamp by the clerk of the court on that document, Your Lordship. Perhaps I can give the court the certified copy. I think that one is just a copy of this particular document. But we just want to request for those certified proceedings to be retained. We intend to use them in other proceedings, Your Lordship. That's why we provided this court with a copy. Just wait. And as I indicated earlier on, Your Lordship, there was in actual fact some cross-examination in relation to these proceedings that took place with regard to the discharge.
Sorry, Mr. Litibeti, I
Yes,
just want
Lordship.
to establish, what is it that the clerk of the court must certify?
As a true and correct copy of the record, Your Lordship.
Okay, why I'm asking, I am aware in terms of which provision of the magistrate's court, because I'm aware, for example, in the High Court, all that, if I need to, the registrar must just certify that this is, these are the proceedings, this is the outcome of the court. Now, what I'm seeing, the certificate by the clerk here, she is saying, the way I'm reading it, she's saying, this is to certify that this is a true copy of the original, and there is no indication that any unauthorized alteration has been made to the original document. So his or her certificate is with respect to the originality of the document and not that it is the proceedings that were in court.
Yes, and there's another certificate at the very end of that document by the transcription services, indicating that it is a true and correct transcript of the proceedings mechanically recorded in court. Your Lordship, I can refer the court, I can read the entire provision for the court.
Of the section?
Yes,
Okay.
of the Criminal Procedure Act, what it says.
All right.
It basically provides in Section 235, subsection 1, that it shall, a criminal proceedings, be sufficient to prove the original record of judicial proceedings if a copy of such record, certified or purporting to be certified by the registrar or clerk of the court or other officer having custody of the record of such judicial proceedings, or by the deputy of such registrar, clerk or other officer, or in the case where judicial proceedings are taken down in shorthand, or by mechanical means by the person who transcribed such proceedings, has a true copy of such record. He is produced in evidence in such proceedings, and such copy shall be prima facie proof that the matter purporting to be recorded thereon was correctly recorded. So it complies with the requirements of the provisions, Your Lordship. And as I indicated, Your Lordship,
Perhaps before my learned friend proceeds with his line of questioning, I just want to get clarification, just with great respect. I have not been provided with that copy. I just want to confirm that whatever is ongoing does not affect my client, because if it does, I will need to be provided with a copy so that I can follow the exchanges, as it pleases you.
Your Lordship, I'm not sure. We gave the instructing counsel a copy of the document. Is that copy? No, it's yours. Your Lordship, I see. They want to denounce their copy. They want to return it to us, but it's their copy. We provided them with a copy. But in any event, it does not relate to Advocate Patela's client, these proceedings. These are the proceedings of Jason Yambo that were referred to in cross-examination, Your Lordship.
Okay.
That is so, my lord.
Okay, then it will exhibit Gabriel.
As it is a court. Where's the additional copy?
Yes.
Your Lordship, I just want to request to provide a copy to the witness. We just refer him to 1 or 2 pages. Mr. Kanyangela, do you have the copy before you?
Yes, I do have a copy.
Okay. I just want to take you to the charges as contained in that document, just on the first page.
Yes, I'm there.
What charge is there depicted as count 1?
Count 1 is Anti-Corruption Act, corruptly giving gratification as an inducement.
Okay. And first alternative, count 1 on the second page.
Count 1 on the second page, it's saying it's in respect of accused 1, 2, and 3, that the accused is guilty of the offense of contravening Section 34A, read with Section 32, 46, 49, and 51 of the Anti-Corruption Act, 2003, Act number 8 of 2003.
All right, and the second alternative to count 1.
The second alternative to count 1 is in respect of accused 1, 2, and 3, that the accused or accused is or are guilty of the crime of bribery.
All right, and on the next page, what is count 2? The third.
Count?
Yes, you just read the second alternative now, right? And on the next page?
The next page is third alternative to count 1. In respect of accused 1, 2, and 3, that the accused is or are guilty of the crime of bribery.
Okay, and count 2? The next page.
The next page, mine is indicating count 5. I don't know, maybe it's a spelling mistake or...
Okay. If you turn over the next page, you'll see the counts again, count 1 and so on. And that is the one I'm referring to. After the third alternative, there will be count 2, which is reflected there. The charges were repeated.
Okay, count 2 is also in respect of accused 1, 2, and 3, attempting to defeat or obstruct the course of justice.
All right. If you turn over 2 pages, who were the accused persons in this matter? There's a third accused depicted there. We'll go back to accused 1 and 2 now.
The accused person in this matter, accused 1 is Jason Iyambo. Accused 2, Sakaria Kutondokwa Kokule.
Okay.
Accused 3, James Nependa Hatuikulipi.
Okay. Now, I just want you to clarify. I think you can just deal with one of the main charge of corruptly giving gratification, that count 1. What were the factual allegations contained in that indictment?
When I indicated this morning, my Lord, and I indicated to my learned friends, that to the extent that they want to use the record of the proceedings, they may do so subject to the rules of cross-examination, subject to the rules of re-examination. The rules on re-examination are quite clear. A matter may be the subject of re-examination provided the issue was raised in cross-examination. Now, the issue that was raised in cross-examination was that in respect of count 1, the magistrate had, in terms of section 174, discharged accused number 1. That was the issue, the only issue on which this witness had been cross-examined. And it was said, as indicated in the chart sheet, that it was in relation to contraventions of the Anti-Corruption Act. Now, to try and broaden the scope by putting on record now what the text of the charges is, Lord, not permissible in terms of the normal rules of re-examination. The witness was never asked about what those charges were. The witness's evidence on the issue was that accused number 1, 2, and 3 were charged with bribery and under offences under the Anti-Corruption Act. But the text of those charges were never put either in evidence in chief or in cross-examination. So my submission, my Lord, is, and I'm objecting to the broadening of the scope of the re-examination. That's the reason, my Lord, that I didn't introduce this issue into cross-examination. Now, my learned friend, with respect, my Lord, can't take advantage of the fact that I desisted from cross-examining and then saying, well, it was raised in cross-examination. This issue was not raised in cross-examination. So that is the basis of my objection, my Lord.
Your Lordship, the reason as to why I'm referring to the factual allegations in the counts with regard to the count of corruptly giving gratification and the count of obstructing the course of justice is simply this. As I indicated earlier on, there was a misconception that was created with reference to the record that the discharge in terms of section 174 was on the basis that there is no evidence. Fine, the law is there, we know what the law says. But if the court has regard to the entire proceedings, that will not be the only inference that can be drawn, that there was no evidence, that is why this person was discharged. Because if the court compares the nature of the charges against the accused person, they're based on the same facts, exactly the same facts. So at the end of the day, to reach that conclusion which was reached by counsel, that there is no evidence, will not be justified having reference to the record in its entirety as the only reasonable inference for the court to draw as to why that particular charge was discharged in terms of section 174, Your Lordship. I submit that it is the natural fact of relevance for purposes of re-examination to refer to these particular charges. And as the court had directed, I objected in cross-examination when only portions of statements were being put to the witnesses because it creates a misleading impression. And I was directed that, well, if I need to deal with those aspects, I will come and deal with them in the examination, and that is what I'm doing at this stage, Your Lordship.
So you are, the way I understand you are saying what was put to this witness is the reason for the discharge in terms of 174.
That there was no evidence. That's why this person is discharged.
Right. Now, will you agree with Mr. Soni that Mr. Soni did not question this witness as to the content of the charge of bribery?
Yes, Your Lordship, but at the end of the day, that is why I was objecting, because it creates a misconception.
No, I will allow you to argue. I just want to get clarity.
Yes, Your Lordship.
Okay, yeah, I see you getting instructions.
Yes, Your Lordship.
No, I'll allow you to get the instructions.
Yes, Your Lordship. And furthermore, apart from that,
I want us to take it step by step before
Yes.
I make a ruling.
yes,
You are saying it was put to this witness that the reason for the discharge in terms of 174 is simply because there was no evidence relating to the count in respect of the bribery.
the corruption charge, Your Worship, charges under the Anti-Corruption Act. For the bribery charge, it's not in dispute. He pleaded guilty on that charge.
He pleaded guilty on bribery.
Yes, Your Lordship.
On which charge was he discharged in terms of 174?
The charges under the Anti-Corruption Act.
Which one are those?
Corruptly giving gratification as an inducement.
Or that's
The first count. It was the first count comes with its alternatives. He was discharged on the first count. The
was he
second,
discharged on the first count,
yes, Your
but
Lordship.
found guilty on the second count?
Yes, Your Lordship.
So, but then if he pleaded guilty and found guilty on the count of bribery, and Mr. Soni did not deal with the content of the count of bribery, can you, in re-examination, introduce new facts that were not placed in the examination, in the evidence in chief, and in cross-examination?
This issue of the charges, in cross-examination, it was raised with the witness that this person faced these particular charges, even though they did not go in detail.
Yes.
So they dealt with what they deemed relevant when they referred to these particular charges. So they did not want to go in detail in respect of these charges for reasons that they may have by themselves, but they did refer to these charges.
Yeah.
And
No, you see, no. This is the question. Is I just want to. If you wanted the court to have knowledge of the content of the charge of bribery and everything, shouldn't you then have dealt with those issues in your in your evidence in chief?
Your Lordship, even if we don't deal with them in evidence in chief, there may be many issues that we will not deal with in evidence in chief.
Yeah.
But if an issue is raised in cross-examination, then certainly we are still entitled to deal with it in re-examination, especially if a misconception has been created in cross-examination regarding that particular
you
issue.
see, you are going into the issue of the bribery now, because the way I understood it is that what I understood is that Mr. Iyambo was found guilty on the charge of obstructing the course of justice. That's how I understood the evidence.
Yes, Your Lordship.
And then he was told that on the, you see, and then what was put to him is on the charge of bribery, he was discharged.
Yes, Your Lordship.
And that was the end of the matter.
No, I think that is where I'm raising this issue, because what I had noted down, they went on further to say that he was discharged because there was no evidence. That is what I'm trying to...
Wasn't that in the debate between you and Mr. Soni? I can't
No.
recall that having been put to the witness.
No, Your Lordship, it was not in the debate. From what I have in my notes, it was put to the witness in cross-examination. That's why I want to bring this
Okay,
issue
why
up.
don't you go to the magistrate reasons of having discharged her, rather than go into the content of what the bribery charge is?
As it plays a court, Your Lordship, I think we...
So maybe what you do then, you go to the reasons of the magistrate, why, I don't know whether it's a he or it's a she, whoever, whatever she may be, he or may be. Why don't you go to his reasoning or her reasoning? Then we are playing within the rules. As I said, I don't want to be too technical in these matters for the purposes of being fair and doing justice. But one can also not allow advantage to be taken of certain things. So what I think the best then is take it on the reasons advance for the discharge. Then you are dealing with what the...
As it plays a court, we will abide by the court's ruling, Your Lordship. All right, Mr. Kanyangela, there's a page 20. If you go to the last part of that record, to the very last, you will note there are two page 20s. The first is in respect of the bail application. The second is in respect of the plea, where it's written Mr. Ueitele on top, page 20. 20, Your Lordship. It should be the second portion of the record towards the very end.
Okay, Mr. Ueitele.
Yes, where it starts with, obviously, he pleaded guilty to. Okay, I think you can just start at page 19. Are you there?
Yes, I'm on page 19.
Okay, just start from paragraph 30. What is depicted on that record?
Is it paragraph or line?
Line 30. Thank you, Your Lordship.
Okay, line 30 reads as follows. Mr. Ueitele, the court convicted him of the second count, which obviously he pleaded guilty to. Court, yes, in respect of the first count. Mr. Ueitele, yes, ruling in respect of that, Your Worship, in respect of that, Your Worship. Court, the state will not call any witnesses on respect of that. Mr. Ueitele, we will not be calling any. Court, that is now count number 1. In the alternatives, the state closes its case.
All right. Okay, thank you, Mr. Kanangelo.
So let me just understand. Mr. Iyambo was discharged in respect of count 1.
Yes, Your Lordship.
Because the state did not call witnesses.
Yes, Your Lordship.
So then there is no misrepresentation.
No, I am saying it's because what you are dealing with is his pending case. The issue before court is that Mr. Ueitele has a pending
what
case.
I want to say is, the way I thought you were saying, the court was being misled in respect of the reasons for the discharge.
No, Your Lordship.
That's how I understood your contention.
I see, yes, Your Lordship.
I understood you saying what you want to prove is the fact that the version that was put to this witness, that no evidence was left, is wrong. That's how I understood you wanting to say. But now what you have taken me through appears to be correct.
Yes.
The state did not call witnesses. So which means the state did not lead evidence.
Yes, Your Lordship.
In the magistrate court. And
yes.
On that basis, Mr. Iyambo was discharged in respect of count 1 and the alternatives to count 1.
Yes, Your Lordship. Maybe just put it clearer.
Yeah.
Because the issue here is basically the applicant, Mr. James Ueitele, has a pending case. So because that statement, it was so broad, the instruction or whatever statement that was put to this witness, that there is no evidence on that charge. So the impression created...
that's what I said. No, that's not how I understood. It's the discharge. And then remember I said to you, this was not put to that witness. I understood that to be the debate between you and Mr. Soni. And that's why he said there was no evidence in respect of the discharge in terms of 174. For Mr. Iyambo, not for Mr. Ueitele, because Mr. Ueitele was not the subject. It was Mr. Iyambo.
Yes, I think that is where the miscommunication came in, possibly between the state and the court.
You misunderstood. It's not the miscommunication. The communication was quite clear. It's the understanding. When I say it's miscommunication, it's when I communicate and you don't get it. But if your communication is clear, but I don't understand, it's my misunderstanding and not the miscommunication from the other party.
Your Lordship, from that instruction, we'll get the record and see exactly the words that were used. Because from that instruction that was put, from a reading of my notes, it was not limited to Iyambo alone, because he's acting on instruction of Mr. Ueitele. That is who he's here for. So when a statement is being put to this witness that...
But this is why I was very clear. And I was saying, my understanding is the debate with respect to Mr. Iyambo. Why Mr. Iyambo has been discharged. That's all I understood. And I think it was quite clear also that the case against Mr. Hatuikulipi is still pending. It hasn't been resolved.
Yes, Your Lordship.
That was made clear in this court.
Yes, indeed. And I think that is what I wanted to highlight, that insofar as the pending case is concerned, it's not an issue that there is no evidence in that pending case or in relation to the
then your communication is very poor. Yeah, you never communicated to us that you are speaking in respect of the case that is still pending. That you didn't say, that I didn't hear. It's only now that you are clarifying it yourself.
As it plays the court, Your Lordship. That was the purpose of re-examination on this particular point.
Okay.
But I think
if it's with respect to a pending case, you should have said that. We wouldn't have wasted these 20 minutes. Yeah.
As it plays the court, Your Lordship. But we'll refer to the record with regard to that particular instruction that was put to this witness.
Okay.
Insofar as re-examination is concerned, Your Lordship, that is re-examination of this witness.
Mr. Kanyangela,
My Lord.
the oath is now done. Now you can go and speak to your wife about anything.
Thank you, my Lord.
Speak to your bosses how you and let them evaluate you.
Okay.
You are released. You may step down. Thank you for having come to testify.
Thank you, my Lord.
Yes. Maybe we must adjourn to just give him time to clear and documents that will need to be remain. So 10. Oh, okay. It's 11:32. Okay. Yeah. Mr. Patela's coffee will call 10 to 12 or 5 to 12.
5 to 12 will be.
Okay. Shall we resume at 5 to 12?
As it plays the court.